Our witnesses will have 5 minutes to provide an opening statement, which will be followed by a round of questions from our members. The witnesses that are appearing before us today are Ms. Carrie Goldberg, founding attorney at C.A. Goldberg PLLC, Mr. Mark Berkman, the CEO of the Organization for Social Media Safety, and Ms. Kate Tamarello, the Executive Director at Engine. I would like to note for our witnesses that the timer light on the table will turn yellow when you have 1 minute remaining and will turn red when your time has expired. Ms. Goldberg, you are recognized for 5 minutes for your opening statement. And again, thanks for being with us.
Thank you, and good morning, Chair Lotta, Subcommittee Subcommittee Chair McMorris-Rogers, happy birthday to you, and Ranking Members Matsui and Pallone, distinguished members of the House Committee on Energy and Commerce. Thank you so much for inviting me to testify today. My name is Carrie Goldberg, and I'm the owner of a national law firm where we litigate for families who've been destroyed by big tech. I stand for the belief that our courts are the great equalizer. In 1791, Congress passed the Seventh Amendment, which gives Americans the right to a civil jury trial. This gives us the constitutional right to hold accountable those who injure us. And I stand against the idea that some bad actors, whether human or corporate, are too important to face their victims eye to eye, to be examined by a jury, or to pay for their harms. That the Seventh Amendment just doesn't apply. Companies that mint money off of the backs of the masses can't later claim when their products hurt those people in predictable or even known ways that it's not their fault and that they're just a passive publisher. And I want to tell you about some of the cases that I work on every day. A child whose murder was live posted and her family is harassed daily by people who defile her murder images. And in her death, Instagram went from her profile having 2,000 users or visitors to almost 200,000 followers. Instagram refuses to give her estate the power to control the account. I represent children who were matched with predators on a video streaming app, including 11-year-old AM, who was used by a man in his 30s for sex and became his sex slave for 3 entire years, and made her go back on the app, Omegle, to recruit more kids. I'm the originating attorney in a case against Snap, where our clients' children were matched with drug dealers who sold them fentanyl and killed them. This case has 90 families in it, and all 90 are mourning the deaths of their kids. One parent is even here today. I represent multiple victims of the serial rapist, Dr. Stephen Matthews, in Denver, who was using Hinge and Tinder as a catalog to find more victims, and Tinder knew about it. I represent a young nurse, or the family of a young nurse from Brooklyn, who was murdered on a Tinder first date by a felon who was erroneously released from prison. I represent a man who was impersonated on a gay dating app, and over 1,000 strangers came to his home in person to rape him while the platform stood by and watched. I also represent a child with profound autism who was matched on a dating app that aggressively markets to children and then was raped by 4 men over 4 consecutive days. And finally, I represent over 30 families whose children purchased a suicide kit online and died the most horrific deaths imaginable. And for 24 of those families, it was an online retailer called Amazon that sold the chemical, aware that there was no household use for it. I do not represent people who were harmed by mere content moderation decisions. In every single one of my cases, the platform knowingly caused the conduct, released a dangerous product into the stream of commerce, sold something deadly, turned a blind eye, or in some cases, all 4. I sue them for their product defects, just like you would if a community was poisoned by contaminated groundwater, or weed killers caused cancer, or an emergency exit door fell off of an airplane mid-flight. Yet in virtually every one of my cases, the online company says that it was just a mere form of speech, that it's immune from liability, and just a passive publisher. Now, over the last 10 years, I've lost more cases because of Section 230 than anybody that I know. But I've also won a few. Congress passed Section 230 in 1995 as an accident in its mission to end online porn. But now it's used by internet oligarchs to shirk the courts and avoid the victims. They make money off their victims, they pay lobbyists, and they amass just an unknown amount of power. Meanwhile, the equivalent of a plane full of children is crashing into mountains every single day while we just wait and watch. In 1997, the court, in a famous case, said, "The internet is a rapidly developing technology. Today's problems may soon be obsolete, while tomorrow's challenges are yet unknowable. In this environment, Congress is likely to have reasons and opportunities to revisit the balance struck in the CDA. Yet here we are 27 years later, but only Congress can fix this emergency. Congress created Section 230, Congress can fix it. And I'm here to support the sunsetting of Section 230 to restore balance. Thank you."
Thank you. Mr. Berkman, you're recognized for 5 minutes. And thank you very much for being with us today.
Thank you. Good morning. Chair Latta, Ranking Member Matsui, thank you for the opportunity to testify. As a former staffer myself, I also want to thank all the hardworking staff sitting back there today, so thank you.